So our next speaker is Hannah Russell, who is currently undertaking doctoral research entitled The Right to Life and European Conflicts at the Law School in Queen's University, Belfast. This research explores the effectiveness of Article 2 of the European Convention of Human Rights in the context of conflicts in the Basque Country, Chechnya, Northern Ireland, and South-East Turkey. She has a law degree from Trinity College Dublin and an LLM in Human Rights Law and Criminal Justice from Queen's University Belfast and the Irish Centre for Human Rights Galway. Prior to starting her doctoral research, she worked as a legal researcher for Disability Action, Al Marsad Arab Human Rights Centre in Golan Heights, the Cambodian Centre for Human Rights, and the Northern Ireland Human Rights Commission, and the Women's Centre for Legal Aid and Counselling in Palestine.
I just wanted to really say from the beginning, I'm dealing with the right to life, which is in reality is a horrible thing to be dealing with. And while I will be taking a very legal point of view, it will be very factual and dealing with laws and case law. I just wanted to point out that is not without ignorance for the pain, suffering and tragedy that are attached to such cases. I also want to point out that because I'll be dealing mainly with the jurisprudence of the European Court of Human Rights, which addresses state actions, it's also not without ignorance for some of the atrocities that have happened at the hands of non-state actors. So with that said, this presentation considers Turkey and the right to life in the context of the Turkish-Kurdish conflict. In doing so, it will present a number of statistics and assess the situation with regard to domestic and international law. It will draw heavily from Article 2 of the European Convention of Human Rights, which is the right to life provision, and the jurisprudence of the European Court of Human Rights. The Kurdish conflict in Turkey has raised a number of issues with regard to the right to life, in relation to extrajudicial killings, forced disappearances, lack of effective investigation and collusion. Since 1984, it is estimated that approximately 42,000 people have been killed as a result of state and non-state actions, and 253 mass graves have been created. A significant but undefined number have also disappeared, presumed dead. Many of the individuals behind those figures have had their right to life violated in some shape or form by the actions or inactions of the Turkish authorities. From a purely legal standpoint, these numbers should be a shock, as the right to life is fairly well protected within Turkish domestic law, and Turkey has ratified its support of most right to life related international standards. However, as is a common story, what is set out on paper does not always transcend practice. At a domestic level, in addition to national homicide laws, Article 17.1 of the Constitution of the Republic of Turkey, 1982, expressly recognises the right to life. However, Article 15.1 of the Constitution does provide for derogation from this right in times of war, mobilisation, martial law, or state of emergency. The terminology used here appears to indicate that the conflict surrounding the Kurdish question fits within these exceptional circumstances for derogation from Article 17.1. Yet Article 15.2 provides that the individual's right to life shall be inviolable except where death occurs through lawful acts of warfare, thus imposing a similar limit as is contained within international laws. Turkey has ratified most international law provisions related to the right to life. A number of them are set out on the screen. While Turkey has not accepted all legal manifestations of this right, it is strongly protected within the domestic, regional and international laws that do apply to this state. When we talk about the right to life, we are referring to the right to live your life without being unjustly killed or being exposed to the threat of being unjustly killed. Violations can occur in situations where a person has been killed or where a life-threatening event has occurred and the person has survived. In considering right-to-life claims, the courts will assess whether a state has failed to fulfil its obligations set out within the right to life, and if its failure is justified. In ratifying the right to life provisions, such as Article 2 of the European Convention, Turkey has committed itself to uphold a number of obligations, with limited exceptions. As this presentation will show, the atrocities that have occurred in Turkey constitute grave, systematic and disproportionate violations of these obligations. Turning focus to Turkey's record before the European Court, surprisingly, only 8.4% of Turkey's violations between 1959 and 2011 have involved Article 2 of the European Convention. It is submitted that this is not a fair representation of the extent of the right to life violations that have occurred in Turkey concerning the Kurdish conflict. This could be due to a number of reasons. First, the often inhibiting burden of proof that is placed on applicants. Second, the lack of evidence available due to collusion and inadequate examinations of evidence by the state. Third, a lack of engagement with the European Court due to intimidation. And fourth, due to practical barriers to the court, such as lack of knowledge of the system, lack of finances, and/or lack of expertise. From the cases that have been considered by the European Court, a number of recurring issues have arisen, which have raised serious questions of Turkey's commitment to upholding the right to life. It is common for state agents to use force in dealing with the Kurdish question in Turkey. States are allowed to use force, but only in instances where the use of force is absolutely necessary given the surrounding circumstances, and the force used is proportionate. In addition, by reading Articles 1 and 2 of the European Convention together, Turkey is under an obligation to ensure reasonable precautions are in place. This includes effectively training its agents on using force and adequately planning operations. Turkey has been found to violate Article 2 in this regard on a number of occasions. This has included using excessive force during demonstrations, house searches, displacement, and destruction operations, and against individuals in state custody. For example, it has had domestic laws in place which allow for excessive use of force, primarily during state of emergencies, the last one which extended from 1987 to 2002, and also outside those situations, such as with regard to Article 11 of the Smuggling, Prevention and Inspection Act 1932, which allows a state agent to shoot to kill as long as warning shots are fired before that deathly shot. Whether the agent feels that their own life is at risk is irrelevant. Furthermore, Article 27(2) of the Turkish Criminal Code 2004 states that a death resulting from actions of state agents brought on by excusable excitement, fear, or anxiety is acceptable. Each of these laws ignores the absolutely necessary threshold. An indeterminable number of individuals have disappeared, never to be heard of again, during the Turkish-Kurdish conflict. There have been reports of individuals being taken from their homes, disappearing at checkpoints, and being victims of death squads. The relatives of these individuals, in the majority of cases, claim that these disappearances have been the result of direct state actions, actions covertly supported by the state, or due to inaction of the state towards death threats. It should be noted that a state is under an obligation to take preventative measures, be it to investigate or to provide protection, where their agents have become aware of real and immediate risks or threats to the life of an individual. Furthermore, in such cases, most of those that have disappeared under suspicious circumstances are individuals who have at some point been accused of being sympathetic towards the PKK. These claims are not always true, but the non-derogable nature of the right to life and its demand for proportionality make an individual's political views and convictions irrelevant when it comes to the threat of the right to life. Generally, the European Court requires hard, direct evidence of state involvement. Yet the court does allow for inferences to be drawn where there is some evidence of the whereabouts of the disappeared individual. For example, in cases where there were eyewitness accounts which reported that the disappeared individuals had been held in state detention and ill-treated after their disappearance. Despite the state's denial it had anything to do with the disappearances, the court has been satisfied that there was enough consistency in the circumstantial evidence to draw inferences that the individuals had disappeared as a result of state action and that they should be presumed dead, thus constituting a violation of Article 2. As a result of such successful cases, Turkey has been found responsible for a number of disappeared individuals and for failing to protect those that were known to be under threat. Turkey has also been found to have breached Article 2 for not adequately investigating the whereabouts of disappeared individuals. As many testimonials suggest, family members of disappeared persons have been met with a wall of silence to their requests for information and investigation. Turkey's general approach to investigating deaths in relation to the Kurdish conflict has been a policy of deny, deny, deny. There is often a denial of any state involvement. There can be a denial of entertaining an investigation to prove that there was no state involvement, or there is often a denial of the applicant's right of access to information. As a result, it became near impossible for applicants to gather the evidence required to satisfy the high burden of proof demanded by Article 2. The court has also been met with two completely different sides to the same story, with no obvious consolidation of the facts. In addition, any domestic investigations conducted by Turkey into suspicious deaths concerning the Turkish-Kurdish conflict are often inadequate, making it increasingly difficult to satisfy the 6-month time limit and requirement to exhaust all domestic remedies set by the European Court. Carla Buckley, in her writings, has found 22 types of inadequacies in Turkey's investigations. These have included undue delays, a limited scope of investigation, inadequate forensic and autopsy examinations, engaging biased and ill-equipped bodies as judge and jury, and employing inappropriate investigators. Consequently, impunity within Turkey has flourished. In recognising this, the European Court has eased its admissibility criteria regarding time limits and exhausting domestic remedies in circumstances where the remedies available are ineffective or incapable of functioning. It has also looked to its American counterpart, the Inter-American Court of Human Rights, for inspiration. Accordingly, the European Court has taken an unprecedented step within the European context and launched fact-finding hearings within Turkey. By 2009, out of the 92 fact-finding missions launched by the European Court, 66% concern Turkey. Turkey's response to these missions is one of contempt. For the applicants, it provided some justice. However, a continuing bone of contention with the European Court's approach is its refusal to acknowledge the systematic violations that are occurring at the hands of the state in the Turkish-Kurdish conflict. That is, that these violations are spurred on by state practice directed at Kurds within Turkish society. Despite a significant number of similar or repetitive cases coming before the court with regard to the conflict, the court has refused to reach a self-initiated conclusion that systematic violations are occurring. It has instead opted to treat each case as a separate entity. The burden lies with the applicant to allege and prove that systematic violations are occurring. Realistically, this evidence will only be obtained with some form of collaboration with state agents, either officially or unofficially. This is unlikely to occur given Turkey's culture of denial and targeting those that show any form of support for Kurds. Targeted killings often form part of covert or often take place as part of covert operation by state agents. That is, that the operations are often denied or covered up. As a result, it has been difficult to prove their existence. With regard to the Kurdish question in Turkey, it has been alleged that the use of targeted killings is rife against suspected PKK rebels and suspected sympathisers with the Kurdish cause. As a result, the right to life of Kurdish villagers, students, journalists, members of political parties, lawyers, activists and armed rebels have been on the receiving end. The UN has reported that the largest number of casualties appear to be as a result of killings during raids and military operations against the PKK. Other sources have reported that these raids have been conducted by death squads, state actors or collaborators who have been tasked with killing off those who are known or suspected to have Kurdish allegiance. An emerging concern with regard to targeted killings is the use of drones by the Turkish authorities. Since November 2007, American-controlled drones have indirectly been used in the Turkish-Kurdish conflict. Turkey has an agreement with America that it will allow American-controlled drones, which monitor Iraq, to be launched from its air bases in exchange for surveillance information. This information has been used by Turkey to launch attacks against suspected PKK insurgents, often leading to the death of civilians. As has already been looked at today, in December 2011, a caravan of 38 men, children and mules smuggling gasoline across the Turkish-Iraqi border were killed by the bombs of Turkish military aircraft. The Turkish military had been alerted to suspicious activity by American drones, and with no further information or regard for proportionate force, reached the conclusion that the individuals on the ground were members of the PKK and should be eliminated. An investigation has been launched into this attack by a Turkish parliamentary commission, and a criminal claim has been brought to the Turkish national courts. Human Rights Watch has reported that both investigations lack transparency, have been subject to unreasonable delays, and have not received the full cooperation of the Turkish authorities. This tragedy provides evidence that Turkey employs the tactic of targeted killings in its conflict against the PKK without regard for its right to life obligations. The European Court has commented on the frequency of the loss of life in Turkey, but has fallen short of expressly stating that targeted killings have taken place. The Court has, however, taken advantage of the opportunity to drive home the obligations contained within Article 2 of the European Convention. In doing so, it has found Turkey guilty of using excessive force, failing to protect against real and immediate threats to life, failing to provide effective domestic remedies such as effective investigations, and on occasion directly responsible for deaths. As Basak Kali sets out in her writings, Turkey's response to rulings against the state has been disregarded as disloyalty to the state or has been covered up with compensation. It is rare for any change to have resulted other than for the state to alter its strategies in the hope that it does not get caught out the next time. There have been some positives to come from the cases brought before the European Court. They have helped to confirm the violations of human rights law that have occurred at the hands of the Turkish authorities against Kurds. Prior to this, due to the lack of effective domestic investigation, these violations were only classified as allegations. They have provided a number of individuals with a voice, which they were previously denied. They have drawn attention from those untouched by the conflict, though unfortunately not to the extent that you would expect. State records have improved to some extent, though they continue to leave out the more damning issues, such as disappearances and intentional killings. There has been some form of normalisation, for example, as Darren has already touched upon, the Return to Village and Rehabilitation Project and the 2004 Compensation Law. Though the Turkish authorities have fallen short of holding those guilty of atrocities to account or introducing extensive reforms to ensure such violations do not happen again, as a result, the European Court's case law only acts as a stopgap and only does so for the select few. It falls short of effectively addressing the Turkish-Kurdish conflict. The main obstacle standing in the European Court's way is the lack of an enforcement mechanism. However, due to global politics involved, the lack of such a mechanism allows the European Court to exist. While it is an imperfect model with frustrating limitations, It is an important one, as the court's fact-finding missions are testament to. There is also the issue that given the dynamics of the conflict, such as this one, no matter what is decided externally, the resolution can only come from within. As a PKK representative has hinted at, with regard to the foundations of this, he has stated that the Turkish state has killed a lot of people. Thousands of civilians lost their lives to unknown assailants. Villages were destroyed and people went missing. The PKK have also killed. Both sides have a lot to forgive. In conclusion, Turkey has implemented and ratified a variety of laws which respect the right to life, yet it has systematically contravened these laws in its actions and subsequent domestic laws in its dealings with the Turkish-Kurdish conflict. Frustratingly, despite continued condemnation from the European Court, this looks set to continue. That is, depending on whether the status quo is changed by the most recent ceasefire. For now, the culture of denial remains.